Good afternoon and welcome. Thank you so much for being here. We will just get started in a few minutes. Welcome. Make yourself comfortable. My name is Sayed Hassan, and I'm with the Migrant Workers Alliance for Change. Hi, everyone. Welcome. If you're just joining us, we've in this session. We'll just get started in a few minutes. Hi, everyone. Welcome. Thank you so much for being here. My name is Sayed Hassan, and I will be helping us facilitate this session. This is our workshop on open work permit for vulnerable workers. I'm joined here by Luis Mata and Marcus from the FCJ Refugee Center, and we'll just get started in a few minutes. So please settle in and we'll get started in just a few more minutes. We see 30 people have joined us already. That's great. We'll wait about 3 more minutes. You know, usually people are running a little bit late, and then we'll get started. We'll do introductions and go through the information. So depending on where you are, if you're in the Eastern time zone, it's 3:03 here. If you're on the West Coast, it's more like noon. So we'll just start in a couple of minutes. Welcome. Thank you for being here. Sorry, I was muted. If you would like to say hello, you can just say hi in the chat box, introduce yourself. We have a Q&A box and a chat box, so you can use the chat box to communicate. But we will just get started in a couple of more minutes once everyone's arrived. And this is a workshop on how to apply for the open work permit for vulnerable workers. So just to make sure you're in the right place. And we will get started in just about a minute. Hopefully you're able to see my screen. We will take, and we would just be starting in 1 more minute. Hi, everyone. Welcome. If you've just arrived, we will be starting in 1 minute. Thank you. All right, we're going to get started. Hi, everyone. Welcome. Thank you for being here. My name is Hassan, and I work at the Migrant Workers Alliance for Change. This is a workshop on open work permit for vulnerable workers. If this is your first time using Zoom and you're one of those very lucky few people, just to give you a brief background, if you're a computer or on a phone, you are able to see at the bottom of your screen a chat button and a Q&A button. We urge you to put your questions in the Q&A section only, and use the chat button to just generally talk to people, but focus on the Q&A if you want to pose a question. What we're going to do today is we're going to do a bit of introductions, followed by presentation by me on the general structure of how to apply for the vulnerable workers open work permit, and then 2 case studies that will be presented by Luis Mata and Marcus from FCJ, who I will introduce in a moment. And then we will do question and answers at the end, and we intend to wrap up in exactly at 4 o'clock Eastern time. So this is going to be a quick educational, we hope. So let's get started. So as I mentioned, I'm with the Migrant Workers Alliance for Change. The Migrant Workers Alliance for Change is a migrant-led organization of care workers, farm workers, migrant students, and other undocumented people. And we are doing campaigns, but we're also supporting migrants to self-organize. This is imagined as a training for legal, of legal information for service providers, volunteers, and supporters of migrants. We have been doing similar sessions for migrants themselves, but this is sort of for the allies and supporters and people who might assist migrant workers, including staff at various facilities. So I want to start off by trying to assess who's in the room. So I'm going to launch a poll, and the poll will emerge on your screen right now. And please take a moment to answer this question. We want to kind of understand who is in the room. So just quickly, if you are able to view the question, just tell us who you work with. Do you work with care workers, farm workers, other types of migrant workers, or if this is not applicable to you at all, you don't work with migrant workers. So we are 22 seconds in. We'll just wait 15 more seconds. I see 26 people have responded. Just you should be able to see the poll on your screen, but of course, if you can't, please respond in the chat. But just if you could respond to the question, we're 33 out of 43. Please answer. 34, 35. Awesome. Thank you. I'll just wait 15 more seconds for the last people to answer, and then I'll share the results so we all know who's in the room. Okay, 10 seconds, sorry, 5 seconds actually. 4, 3, 2, 1. Okay, so let me share the results with you so you see who's here. So we've got 9 people who work with care workers, 9 people who work with farm workers, 12 people who work with other migrant workers. So that's the largest number, and 9 people who this is not applicable to. So that's great. Thank you for being here. We are going to be focusing on the work permit for vulnerable worker open work permit, which is for employer dependent permit. So this may not be fully applicable to you. This is legal education if you're not working for, but we will at the end talk about how to support people who do not qualify for this. Okay, so now we're going to do a second question. I just want to get a sense of what your experience is with working with. Have you ever made an application for an open work permit before? So you've got a number of options. Yes, all your applications were successful. Some were successful, some refused, all were refused. No, you're planning to apply, and you're here to see if this is applicable to who you work with. So, or other, which would be different. So please quickly, if you could just respond to this question, it will also give us a sense, and we'll be able to make sure that our information is more targeted and focused to you. I see 32 people have responded, 33, 34. Awesome, keep going. Just 15 more seconds, just quickly. 10 seconds. All right, just get the stragglers in. Make sure you answer the question. Okay, great. So I'm going to share the results just so everyone can see. I hope you can see the results on your screen. So it can see 6 people applied and all their applications successful. So that's great. Hopefully you'll be able to answer some questions in the Q&A session. 2 people applied, some successful, some refused. Nobody's applied and all the applications refused. That's good. 4 people are planning to apply, and 22 people are here to learn if this is applicable to who you work with. So that's a very large number. So that's something we'll cover right at the top. And 5 people are other, and I'm not so sure what that means. But thank you so much for being there. So that gives us a sense of who's in the room and what it is. So 9 work with care workers, 9 work with farm workers. This is useful, Marcus, Luis. This will help us make sure we direct our answers appropriately. So let me now jump right into the program itself. What is the Open Work Permit for Vulnerable Workers? So this is a program that's been being devised since the end of 2019, and it is a program for temporary foreign workers on employer-dependent work permits to be able to apply. This is a direct result of migrants speaking out about abuse and exploitation. I have a screen grab here from July of 2020, where a number of migrant advocates speak about this program as a band-aid solution. It doesn't resolve all of the concerns. It isn't a panacea. It doesn't respond to the primary call for migrants, but it may be applicable for certain people. And I think it's important to approach this as that, as a potential tool that some workers may be able to access to. Sorry, I went back. Okay, so who can apply? This is about eligibility criteria. So there are 3 specific eligibility criteria. First, the migrant worker must be in Canada. Second, they must have a valid employer-specific work permit at the time, or they must be under implied status. Implied status, that is, they applied for renewal of their permit or their status, and they are waiting for a decision, and they must be facing abuse. It's important to note that they do not need to remain in the abusive workplace in order to receive the permit. They can be out of the workplace where they're being abused, so the abuse may have technically stopped. And it is about vulnerability to abuse, which I will speak to in a moment, which is different than having been abused. Okay, so defining abuse to migrant workers. We understand, the word abuse is not exactly the most empowering word. Abuse is not necessarily empowering, but this is how the federal government understands abuse. So this can be, when you're speaking to a migrant worker, this includes, sexual abuse, which includes unwanted comments or touching, physical abuse, which is, beating, verbal abuse, including threats, forcing you to do things you don't want. This could include drinking alcohol or taking drugs, asking you to pay really high fees to get or keep your job, not paying you or controlling you how you spend your money, controlling where you go and or what you do in your free time, withholding your passport or work permit, threatening to send you back home, doing anything that makes you feel unsafe or limits what you can do, and abusing your co-workers in any of the above ways so you feel scared for your own safety too. Now, it is important to remember that it does not necessarily have to be the employer carrying out these activities, but that abuse is happening in the workplace, so it potentially could be your co-workers. As I mentioned, we will talk about what if someone's experiencing this, but they don't actually meet the criteria of one of these criteria in a moment. Okay, so how do you apply? Now, if you are supporting a migrant worker who is facing one of these situations, the way for them to apply is to go to IRCC, create an online account, and through the online account, if they follow a series, they will be able to find the application for the open work permit for vulnerable workers and apply directly there. This application is free and includes the work permit application form, the IMM 5710, and evidence of abuse. I'm not going to be spending any time speaking about how to do a work permit application today, but if you need that and you haven't done that before, we can speak. You can connect with us, and we have some information at the end on how to get in touch with us. So what's different? One of the things is for this work permit application, you do not require biometrics at the time of the application. So these are fingerprints. It is, of course, possible that once an application is being made by the migrant worker, the officer may request them during processing. Now, how is the evidence of abuse? An evidence of abuse could be, but is not limited to, these are just some examples, a letter from a doctor or a community organization aware of the abuse. So this could be you, who the worker has informed of the abuse. Emails or text messages that show abuse. These could be emails or text messages by the person doing the abuse, or emails or text messages sent by the worker to other people, telling them what is happening. Photos which show injuries or abusive work conditions. Names, phone numbers, and letters from anyone who witnessed the abuse. So if you have anyone who's witnessed the abuse, it's important for migrant workers to immediately move to getting evidence from them. They can write letters. It is also important for the application to accompany a letter from the worker. Often this is referred to as the narrative. You'll hear that when Luis and Marcus speak, describing in detail, including not just what happened, but what the impact of the abuse is. And copies of police reports or label complaints if they are made, but they are not necessary. You don't have to have filed legally and any complaint but you will hear how this comes down to officer discretion in a moment. And these documents can be in any language, but must be translated to English or French. So any evidence that workers can provide that can go into the application is very useful. Now, it's important to note that the government has also defined specific forms, has given new examples of abuse during COVID-19. So these could include people being forced or pressured to work when sick and showing symptoms or during quarantine periods, reprisals for taking sick leave, prevented from receiving health care, not provided with adequate tools and working conditions to implement public health and social distancing protocols. These, of course, are abuse no matter when, but they are being more clearly looked at right now. Now, what happens once the worker applies? So a worker comes to you, shares this information, you assess with them if they are a good fit, and then they apply. What happens next? The immigration office is supposed to contact the worker when they receive the application. The timeline is supposed to be 5 business days. As you'll hear from Marcus and Luis, that is not being followed, particularly during COVID-19. It has gotten worse. At the time that the officer, so these are 5 business days, but it is, I shouldn't say sometimes, usually much, much longer. But generally it is shorter than it takes for a work permit to be approved right now, because right now we know work permits are taking 6 to 9 months in some cases. When the officer contacts the worker, they will be asked to do an interview. They may be asked to do an interview, and they may also be asked to do a medical exam. Now, workers can choose to submit a medical examination with their application. This is true for some care workers. And if they do, they have to pay for the medical exam. But remember that there is no necessity for such a thing, but it seems to be being asked from most care workers that we are aware of. So how do you prepare for this interview? We'll hear a bit more from Luis and Marcus about Marcus in particular, and I think about how the preparation went. But we've heard different reports on interviews. Many of you who've applied might also have more information to share, and they seem to vary based on the immigration officer assigned. Immigration officers have discretion to allow for a support person to be present or an interpreter, but they do not have to allow one. They may ask for more information during the interview. We have heard, for example, workers being asked to provide, log into their Facebook Messenger chat so the immigration officer can review what's there. It is important that before the worker goes into the interview, if you are helping them prepare, that you go through the narrative letter in detail, that they are well aware of the evidence, they're well aware of the facts, that you've done a few practice rounds with them, because people may be stressed, they may be alone, they may be speaking in a foreign language, and this is a place that they may trip up. Or they may be tripped up by the immigration officer. So it's important to help workers prepare for this interview once the application is filed. Okay, while the application is being processed, which is from the moment it's filed, including during the interview process, immigration will not ask the employer for more information or tell the employer that the worker is applying for an open work permit. So this is something you can tell workers in advance. Now, if the worker is still with the employer, it is important to ensure that they are able to have conversations with you in private and that the devices are not monitored. In one case, somebody we worked with, their phone was provided to them by the employer. This is a live-in caregiver who was just days away from filing their open work permit application. The employer checked the phone, found out, and fired her. So it's important to be, when communicating with a worker who's at work, that you are making sure that there's privacy. This is true actually for most times you're working with migrant workers, but it's also true here, particularly sending documents back and forth for them to review, etc. Now, if the worker has left the employer, it is important to understand that this is not, while people are waiting for open work permit, they may not have access to income. They may also need to do a labor rights complaint to get back the wages they're owed, because this application doesn't actually result in anything but immigration changes. They may need other forms of social support. They may need housing. So it's important to support the whole of the worker, and you can get in touch with us so we can help you with that if this is something you do not have expertise in or want more relationships or contact in. Once the application is successful, the worker must wait for the open work permit to arrive in the mail before beginning to work. Can start searching before. It is important to note that when you are on an open work permit, workers can work anywhere except employers listed as ineligible or workers who are employees that regularly offer striptease, erotic dance, escort services, or other erotic massages. So we know that though sex work is not criminalized, immigration system does make it impossible for people to earn a living in this way. Once there is a decision on the application, it is possible that the federal government may inspect the workplace that a worker may make complaints of and may in fact even ask for more information from the worker for the purposes of the inspection. Now, length of permit and renewability. Length of permit is variable, approximately 1 year, but there is no limit. There's no timeline in the regulations themselves. Sometimes work permits are being issued only for the length of time left on the work permit. So some people, they were, say, on a seasonal agricultural worker program. It's until December 15th. They're being issued only until December 15th. In other cases, they're being issued a whole year. Now, this work permit is non-renewable. This is one of the problems with it. And it's not renewable, and as a result, once workers are not really able to use it towards other means. But during the time that they're on the open work permit, they may be able to apply for other permits that they're eligible for or permanent residency if they fulfill the requirements. I'll speak to that in a moment. So if workers are eligible for certain programs, but the work permit itself is not renewable. Now, impact on permanent residency applications for care workers. Having or applying for an open work permit has no impact on a PR application, right? But for migrant workers who have not completed their 24 months of work experience, they will not be able to amass that work time until they have received the open work permit and they start working in one of those jobs, and then they can start using it for their in-home pilot project or personal support worker applications. Okay. Now, impact on migrant farm workers. For migrant farm workers in the seasonal agricultural workers program, who must be invited back each year, leaving a job means that the employer will likely not invite them back. As a result, once a worker has left the job, applied for an open work permit, they'll end up in a general pool of applicants coming to Canada through the program because the employer won't be inviting them back. Now, there are concerns about blacklisting, that people who are getting open work permits now may not be able to come back to the country in the future. This is something we're specifically in conversation with federal decision makers about. If you are aware of, or you've applied for someone, or you have any questions about it, please contact us. And again, I will share my contact information at the end, but you also received an email about this webinar that would have given you that information. Okay, moving right along. It is important to note that migrant workers with families who have family members in Canada, they may be eligible for an open work permit if the migrant worker who is the principal applicant is approved. So this is primarily temporary foreign workers in high wage streams who come here with family work, on closed work permits, but with family members. Family members must complete their own application and submit it together with the principal applicant. Now, what happens if an application is denied? There is currently no appeal, right? Migrant workers can do a judicial review of the application. This is true for all immigration applications. If you're not aware, a judicial review is when you go to court and ask the court to rule on whether the decision was legal. So these decisions do not assess the facts of the case, but rather assess whether the law was followed. The success rate for judicial review on immigration applications is very low. It is possible that the worker may be able to apply again. That does not necessarily mean, but if you are able to find out if there was any specific weaknesses that can be fulfilled, you may be able to apply, but I'm not personally aware of anyone who's had a success at a second round application. Maybe we can hear that. If you know of someone, please put it in. Okay, What about migrant workers who are being abused but are ineligible to apply? So if you are working with a temporary foreign worker who is not on a valid work permit or an implied status, a valid employee dependent work permit, I would like to add, and who's in Canada, so what do you do? We know that this is happening with a lot of people. If you're in touch with any migrant document person who is being abused and they are ineligible to apply for this permit, please contact us to strategize. It is important for us to support all our people, and particularly because we have been calling to make this work permit an option for many other workers. So if we can gather stories of people who have been in such a scenario, we'll be able to improve laws. This is a new program, so we have still some openings. So now I am going to turn it over to Luis and Marcus. Luis is a Colombian refugee trained in human rights and in immigration and refugee issues. He works at the FCJ Refugee Center supporting migrant workers. Luis is going to talk us through for about the next 10 minutes about examples of applications that have been denied, is my understanding. And then followed by Marcus. Marcus is Brazilian international student currently working at the FCJ Refugee Center supporting migrant workers. Also, he's going to give you examples of successful applications, at which point we will turn over to Q&A. Now, if you've had questions in this period, again, I urge you to type them into the Q&A chat, Q&A, not the chat, but the Q&A option, so that we can look at all of them and respond to them together. So I will turn it over to Luis. Luis, I'm going to mute myself.
Thank you, Hassan. Thank you so much, everyone, for the opportunity. Okay, I'm going to start with mention that some elements that we have found in the denied applications. The first thing is the disconnection, the total disconnection between what is happening in the reality and what is the case of the person who is applying for this open work permit. I wanted to recall here that one of the colleagues working in other organizations said sometime the Amnesty International sent us in Canada many information about human rights violations around the world, but will say nothing about human rights violations in Canada. And we should be receiving those because these officers working in the immigration, doing the interviews or processing the applications, they don't have a clue about what is happening on the ground. They don't have a trauma-informed approach training in order to see what are in what ways have been affected emotionally the worker when he or she is forced to apply for this remedy. And the second thing I would like to say is that Canada, the whole system is working wrong, in the wrong way, because those policies created for the temporary foreign workers program have been creating a gap and the possibility for the workers to be victims of abuses and labor abuses and exploitation. And in other means, the policies have been provoking the injured. And then the government comes out again with that band-aid, as Hassan said at the beginning. But these band-aids are totally ineffective in the long term because they don't have pathway to permanent residency. That is things that I wanted to mention before mention specific cases. One of the cases I would like to bring today is we received a letter for one application from a Guatemalan worker. This Guatemalan worker was severely abused in the farm. He was working in a farm in British Columbia. Several kind of abuses, not only emotional, but there were from the employment standards. Also, they were getting deductions, illegal deductions, and the housing condition was very poor. Several issues together involving the situation make these workers desperate, and they just left the place because they had a connection with another worker in Ontario. They came to Ontario. I'm talking about 3 workers. Finally, where the group was composed by 5 workers, but let's talk about these 3 workers and one specific case from those 3 workers. They came to Ontario, and then in Ontario, They started being surviving in several kind of jobs until they were informed that this remedy exists. When they contacted FCJ Refugee Center to see what they can do with the situation they were living without status, one of the workers had the work permit valid, still valid, but the other one already expired. We work with both of them, and the submission for the application for the one who had the work permit valid, we were hoping that the application was going to be successful. However, many things were combined in the decision, the negative decision coming from immigration. One of the, can you pass the next slide, and then we're gonna get back again to this. One of the comments in the letter was saying that asking the worker if they were be able to put a complaint against the employer. That was one of the comments in the letter. And the other one was related to evidence about the abuse. Can you get back to the prior slide again, Hassan? Again. Then, how a worker who has been working in isolation without language to be communicated in English. Also, a person who was not properly informed about the rights, the labor rights, and the conditions, and a person who signed a contract that he didn't know what was in that contract, and the way he was going to work here changed dramatically. One thing was told him at the beginning, but another thing was happening in the ground, totally different. Different kind of job, different kind of tasks, different kind of payment, and the housing conditions were terrible, etc., etc. This worker, without information, without language, abused, scared because he didn't know what to do. Also sick. How this person will be able to put a complaint against the employer? If he knows, if he complains, then he's not going to be in the list for the following years. For the upcoming year, the only option that this worker had was to leave the place. He left the place, but when he left the place, he was not working anymore in the place. Then the decision or the application was negative because he was not able to provide enough evidence that he did a complaint against the worker. That is one of the cases I wanted to bring here because it's totally unfair. Now you can go to the next slide. And another case that we had is the worker was called for an interview, and the interview the interview approach was undermining, totally undermining the fairness for the worker, because the worker was not totally prepared to answer, and the person who was doing the interpretation was doing a wrong interpretation, and the worker was scared. In other words, was a very problematic interview. That kind of interview is totally against the rights of the worker. And again, the trauma approach training of the immigration officer was totally, that officer doesn't have any kind of training in this sense. The worker was more focused in the removal issues than in the abuses that the worker faced in the place of work. Then this inconsistency, this fact, in our opinion, in my opinion, is a violation of the labor rights and a violation of the human rights of the worker, because it's a re-victimizing the worker. The worker was unable to sustain what was happening in the farm. Also, in the guidelines of the open work permit, there are a list of possible violations of the labor rights, very well enlisted. However, when the worker is going to sustain those abuses and has no evidence, let's say recordings or pictures, just the voice, what we do in the center is to organize an affidavit and a declaration, a legal declaration. In that declaration, the worker is providing the evidence with dates, with names, with describing the situation. However, when the worker don't provide those evidence that supposed not to be mandatory, then the application is gonna be denied. That happened in one of the cases I mentioned it before. It's very difficult for a worker to support the application with evidence when those abuses happen in an environment that the worker is afraid, unable to reach, let's say, an officer or a liaison officer or social services or something that provide him or her the proper information to elaborate a complaint. The purpose of the vulnerable worker is to provide workers who are experiencing abuse or are at the risk of abuse, as Hassan said at the beginning, with the means to leave their employer. But what happened when the worker left the employer? And a time has been happening between the moment he left the place and the moment he applied. That is a dramatic situation, because even though the worker has the work permit, they still having the work permit, the cloth work permit valid, is unable to do the application because it's very difficult to be accepted in the application, because this time has been crucial to do an investigation. That was the comment one of the letters of the officer, the officer mentioned in one of the letters, saying that you have not demonstrated that you reported your employer to an agency. But again, coming back to the beginning, how a worker without language skill, isolated and afraid, can do this kind of report? Can you go to the other slide, please? The next slide, Hassan, please. Okay. In those cases that we have found or we have received negative decisions, there are three things that I want to highlight. One, this is a mistake, is wrong that the decisions are discretionary to the officer. There are no guidelines based on human rights and on labor rights that provide enough direction for an officer to take the decision based in facts. A decision is most likely taken in discretionary way, means the officer has the decision if it say yes or not. And also, when the officer is totally disconnected from what is happening in the ground, not knowing that the labor violations are happening around in the context, then it's totally inflexible. It's totally is not able to provide a possible decision because he doesn't know, or the officer doesn't know. Then it's based only in his discretionary decision. This is a sample that I took from one of the letters. Based on your application and the accompanying documentation that you have provided, the affidavit, the letter of support we did, I have carefully considered all information, and I am not satisfied that you meet the requirements of the Immigration and Refugee Protection Act regulations. Then, several things here. One, the worker has been re-victimized again. No trauma-informed approach from the immigration officer. Focus only in the removal, no focus in the abuses. Second, inconsistencies. There is a list of abuses enlisted in the web, in the IRCC web. However, when the worker enlists those abuses in the letter, saying those were the situation I face in the place of work, housing, verbally maltreated, coerced, etc., etc. But if the worker doesn't have enough evidence about that, means physical evidence, pictures, recordings, etc., then it's not going to be approved. And also another element that I wanted to mention is we have found that in one case, there are 5 or 7 workers involved in the exploitation, in the abuses. Each one of the workers has to do an individual application, and each one of the workers has to provide evidence. That is not fair, because if the situation happened in the same place of work to the same group, should be just being approved, with one application being approved the whole group. That was the should be the fairness in this case, but it's not happening. The next, please. And the final, I think. Okay. Those are the comments. The comments I wanted to bring. Just to close, that workers who have left the place of the abuses and time has been happened between the moment they left to the moment they applied, they most likely are going to be denied, or is a very difficult application to be approved. This is one of the situations. We have had from those cases around 4 or 5, which is one of the elements I wanted to highlight. Okay, Marcus.
Okay, thanks so much, Luis. I just would like to wrap up and show a little bit of examples of successful applications that we had and the evidence that we use on that applications. We know that unfortunately not every worker goes to work and they have in mind, oh, I need to take pictures of the abuse that's happening. I need to generate evidence to support my application, because the workers, most of them, they're not aware of this application. They're not aware that they need to generate evidence. So their main concern is to leave the abuse, is to leave the housing conditions that they are facing and look for safety, right? So their main priority is not to generate evidence to support an application that they are not aware of. So that's one of the main concerns that we have with workers. But with those that we had evidence, there is one case that MWAC was deeply involved. It was in the media, so we had videos, we have newspapers, we had pictures of housing conditions, we had all that. These applications had like 70 pages of evidence for this open work permit, and it was approved in less than 24 hours, for example. Other cases where we had less evidence took 2 months for us to hear back from immigration. So the response time will vary, and we have this relation like as more evidence that you support, as you provide, quicker is gonna be the evaluation by the immigration officer as well. So what we usually use as evidence, we do an affidavit with partner lawyers that we have. We collect pictures if the workers have pictures of living conditions as the one of the examples that we are showing. Text messages between them and the supervisors and the managers, any kind of evidence showing the abuse that they suffered, not only their word. Unfortunately, immigration will not rely on their own testimony, on their own word of what happened. They need proof of what happened. And this can include pictures, videos, text messages, letters. Usually FCJ, we provide a letter of support saying that we are in close contact with this worker, that we recognize the abuse that they have been through. And we usually go to IRCC website, we copy and paste their own definition of abuse. We use that on the letter so they can identify themselves. Oh, okay, this really is a situation of abuse. Hassan, I think we can move along and we can wrap up with the questions.
Okay, thank you so much, Luis and Marcus. So before I go into the Q&A, which we can all see, it's important to know that, so please, if you have any questions, please put them in the chat right now. But what I would like to say to you is, we want, as you heard, it is difficult and it's discretionary, but it is worth applying for, because we are trying to gather information about those who are being denied, even though it is against the regulation. So we want you to, where it is appropriate and safe and manageable, to apply. So we're now going to open up the space for questions. So you have to type your questions into the Q&A. And so we are going to just look at the questions over there and we will answer them one at a time. So if you want to take a moment, just somebody, okay, so we'll start there. So somebody said, oh, can you go back to the first slide? I was not finished taking down the notes. Thank you. So we are going to send you a guide with how to apply. So you will be able to get some of that information. We will share some more information in just a moment. So the question is, what are the consequences of unauthorized work after leaving the abusive work situation? Any tips for dealing with unauthorized work in the open work permit application? So this question, I'll first see if Marcus or Luis wants to respond, but basically a worker left, they didn't have income, so they started work. What do you put in the work permit application? Marcus or Luis, do you want to respond to this? Marcus, you're up, go ahead.
Yes.
Oh, Luis, go ahead.
Okay, normally what we do in those cases is when we are doing the narrative or working in the narrative with the workers, the worker should say that he is living with somebody, with a friend, and normally we invite them not to declare that they are working. Everybody knows that the worker is still doing something, but the worker needs to survive. If the worker will be in violation of the IRPA saying that he's working without authorization, that is not, nothing has been written or said in the guidelines that is going to be then avoided to apply for the open work permit, or is going to avoid him for this option. However, that in the narrative we just avoid declaring that he's or she's working.
Maybe I'll add just one thing. So legally, if a migrant worker in their work permit application is asked about previous work and they choose not to disclose particular work, then they are misrepresenting themselves in the application. The consequences of misrepresentation is that you can possibly be banned from the country for 6 months to up to 5 years. So it is a decision that people need to make. So you may choose, it is on the worker to choose to disclose that and deal with the consequences, or choose not to disclose it and deal with the consequences. But I think this is as Luis mentioned, in some cases people are not. Other lawyers will tell you to never lie. So I think it is a difficult decision. There's no certainty that the open work permit will be denied because they were doing this work. So it is a decision that workers need to make, and you need to make about what the most appropriate task is. So there's a question here. Can you please clarify the use of interpreters during interviews? So Marcus or Luis, do you have experience with interpreters in interviews that you would want to share, and how you've gone about negotiating with immigration officials to allow you to participate or allow someone to participate in the interview with the worker?
I have not been in any interview for the open work permit. I have been in other kind of for TRPs or others. However, we received the feedback from one worker from Mexico who was called to the interview. He was complaining that the person, that because this worker had basics in English, so he was able to understand. And what he said that the interpreter was messing up with the answers. He was not expecting the interpreter to be collaborative, but at least to be honest and to transfer what he was saying. And he needed to interact several times to say, okay, that is not what I'm saying. And that was very difficult because he was not able to understand fully the English, but he was understanding something, and the interpreter was a problem. It's a problematic situation.
So I think I should have been more clear. The interpreter that you may want to provide. So of course we know that appointed interpreters sometimes aren't very good. So having our own interpreter or a support person in the room that accompanies the worker that we have arranged. Sometimes we have been successful in allowing them, but other times we have not. So we are in this process of, so it is about, negotiating that. So in one case, for example, it's discretionary in the sense that the immigration officer can just say, we'll find our own interpreter, no support person is allowed. So I misspoke, so thank you for that question. Alois is asking, are there any discussions on extending the expiry date of the open work permit for vulnerable workers because of COVID-19? We are in a process of negotiating with the federal government around immigration rule changes. This is in many things, including renewal of work permits. Currently, any permits that have been denied in Canada, the restoration period has been moved to December 31st. So if the worker is in Canada, they're able to renew any permit, except we know this one is not. We currently haven't heard if this will be made renewable. But as many of you know, and I'm going to go into that slide in just a moment, we are talking about full and permanent immigration status for all as the solution. But the government has not indicated they're making these permits renewable. Are there any other questions that people would like to ask? Oh, yes, perfect.
Okay.
Go ahead, Luis. I'm just
Hassan, about the prior question. We have been also participating in discussions, and we went to a consultation with IRCC, because this is wrong that this open work permit has no extension, no possibility to be extended. And during the COVID-19, workers have been granted with this open work permit, they have been unable to find an employer because of the situation. Then they are in a kind of limbo because no extension, but also no opportunity because the situation to apply to get a new employer. We did an application anyway for renewal. We did an affidavit and a declaration, and we wrote a letter from the FCJ Refugee Center trying to support to try it. And the answer was definite, that is not possible, doesn't exist in the guidelines. And the only option that the worker has in this case is, or not the only, but one of the best options is to apply for humanitarian and compassionate grounds for permanent resident. No? That is one of the options that is anyway difficult.
So there's a next question, says, is there an organization that would educate workers on the possible issues that may arise in their workplaces before they actually face the problems and before they start the job? So we are organizing the collective self-organizing of migrant workers. And so we'll share our phone numbers about whether they are farm workers, care workers, or international students, where they can connect with other workers who can help build up their organizing capacity, share rights information. So that is part of the work that we are doing, because absolutely reactive and complaints-based processes don't work. It is important to know that workers are well aware of their rights, but don't have the power to enforce them often because of their lack of permanent resident status, which is why the primary demand of the migrant worker movement, the migrant justice movement, particularly now, but has been throughout, is full and permanent immigration status for all. Okay, we'll take a few more questions before we wrap up. So please, if you have questions, please type it in. So somebody has said, if I have a client whose work permit is set to expire in January 2021, would an open work permit only be renewed until then? Marcus or Luis, would you like to respond to this?
Marcus?
Yeah, sure. Yeah, so in this case, not necessarily. There were cases where they gave the open work permit the same expiry date as the previous work permit, but at least the applications that we did here in the office, the majority of them were 1 year, 1 year work permit, open work permit. So the argument of immigration is that this 1 year open work permit is a bridge for you to get a new closed work permit with a new employer, which will just cause the same issue over and over again, unfortunately.
Unfortunately, a lot of what we're saying to you is it is discretionary. So you have to apply and then see what happens because they're not following the rules very clearly. The rules themselves are confusing. But the more evidence that you can gather and support the workers in gathering, the more effective and successful it will be. Are there any other questions that people would like to ask? The Q&A box is open, so please type in your questions. Just give you one more minute. In the meantime, I'm going to reshare my screen. So while we're waiting for questions, these are direct hotlines for connection to, so if you're working with migrant farm workers, English and Spanish, migrant care workers, or other migrant document workers, these hotlines connect you directly to people who can then connect you to, who can connect. So these are for workers to contact. So if you are looking for workers, so reach out, get the workers to call these numbers, and then they will connect them, identify where they work, and connect them to social support, know your rights information, and the like, anywhere in Canada right now. So these are our numbers. I understand FCJ has a number that you can reach out to both as a service provider or as a migrant worker to help to get assistance in your legal complaints. So these numbers can, often we are turning to Luis and Marcus to help us with the complaints also, but you can also get in touch with them. So maybe Luis or Marcus, if you want to drop in your information in the chat.
Yes, Hassan, I just put the WhatsApp number we have in the center for migrant workers particularly. We have been dealing with a number of applications, but not only the open work permit. We have some expertise and some experience doing the humanitarian and compassionate applications and other kind of applications. Then workers can call us also, and we explore options together and provide proper information. And just wanted to say that we work in partnership collaboration with MWAC all the time. We have common clients that MWAC has been doing the legal approach, working together with Pardel Community Legal Services or other clinics. But meanwhile, we have been doing the open work permit, then we work together in that. That is very important to say that we have a conversation, and this partnership collaboration is important to provide the best services possible to the workers.
Thank you, Luis. I see that there are a few more questions, so we will respond to them in just a moment. I'm sharing something else in the chat. So as I mentioned, this is a new program. So if we are looking to gather evidence to campaign to get the government to change this. So if you please share your experience with us, whether positive or negative, by emailing us at info@migrantworkersalliance.org. And you can also share questions. At the same time, this is a separate issue. So maybe what we'll do is we'll take the Q&A again, and then I'll return to that in a moment. So there's a question is, and we just have a couple of more minutes, so we'll be wrapping up very soon. We'll just show you a brief video at the end, so it might go up a couple of minutes later, but I promise you it'll be great. So Alice asks, is it possible to appeal a refusal decision of the open work permit for vulnerable workers? So no, it is not. You can do a judicial review like you do with any other immigration application, but as you know, that is quite difficult. Okay. Now there's a question, is any tips on disclosing the abuse to ESDC? So I'm going to assume that what you're meaning is not during the open work permit process, but to ask for ESDC to participate in doing some sort of inspections. So yes, ESDC has a phone number and an online form through which you can share information. This is this is not a communication mechanism. You can give them a tip and they may or may not respond. It's very important to talk to workers to make sure that the tip does not end up causing reprisals. So a small workplace with just a few workers, if you get information, you make a complaint, it will probably blow back because the employer will be able to identify who was involved. So yes, see, there is a complaints process, but it's important to do it in a thoughtful manner. We encourage you again to call the numbers that we shared, that you'll be able to do it. So The next thing I want to share, and this is, so I think those are all our questions for the day. So thank you so much for being here. Just wanted to share two things with you. So the first one is, particularly right now, the federal government is reviewing housing. And we, along with FCJ and many other groups across the country, have conducted a survey of nearly 500 workers, 453 workers, about their opinions on housing. And we have created a document that we've sent to ESDC, but we need each of you to write a support letter in support of worker demands, if possible. So if you go to the link that I dropped in the chat, you are able to make a phone call. And I'm sorry, able to download a template letter, and you can use this template letter to write a letter to ESDC with your support for these. So if you're able to do that, if your organization is able to, help amplify directly migrant worker voices, that would be very strongly appreciated. So I am just going to take a moment and now share a short video with you of migrants themselves speaking about the Status for All campaign, which is such a major priority at this moment, defined by migrants themselves. So I'm just going to hit play on a video.
We want full and permanent immigration status for all.
Permanent immigration status ensures that we migrants are able to protect ourselves. This is the time for the government of Canada to acknowledge this right and act to make this happen.
Cuando guardé silencio, no pasó nada. Tenemos que seguir luchando para que todos tengamos vidas dignas y seguras.
We invest everything we have to build our future here, but we have no protection or support if something goes wrong. We have no guarantee that our work will pay off and that we'll be allowed to stay.
Especially during this time of COVID, it's time for us to realize how interdependent we are.
In Canada, the rules are equal for everybody, but when we are tied for your employer because of your immigration status, the rules are not equal anymore.
Es difícil pasar por esta situación, pero voy a luchar hasta el final y no voy a parar hasta lograr un cambio. Y estoy aquí junto a todos ustedes exigiendo la residencia permanente para todos y todas y todos los migrantes. Respeto y igualdad para todos.
Status for all! The time is now! Status for all!
Great. Well, thank you everyone for being here and joining us in this session, for your questions and your comments, and for especially to Marcus and Luis for sharing your expertise and your wisdom. So I urge you to go to migrantrights.ca and sign a petition in support for Status for All, because as you can see, that's what migrant and document people are calling for. And if your organization is able to write a letter in support of the Housing Council, in support of migrant worker voices in the Housing Consultation, that's the link you have there. And we also urge you that if you are making these applications, to get in touch with us and share your experience with us, both of success and failure, so we can document how the system is not what it's being promised, so that we can urge immediate and long-term immigration and legal reform. Thank you so much for being here. That concludes this session. You'll be receiving a video of this session as well as a PDF document that summarizes that you can actually give directly to migrant workers. It's currently just in English. So you will be receiving that from us shortly. So thank you so much for being here, and goodbye for now.
Thank you so much, everyone. Have a nice day.
Thank you so much.